Wonderful.
Clear.
Okay, great. In accordance with Section 5 of the Open Public Meetings Act, be advised that notice of this meeting was made by posting on the bulletin board in Town Hall and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place on Wednesday, December 1st, 2021 at 7:30 p.m. via the Zoom virtual platform. Due to the COVID-19 virus, Millburn Town Hall is closed to the public for the purposes of planning board meetings. The meeting notice contained information necessary for members of the public to attend the meeting through the Zoom platform, both by audio and/or video means. The public will have the same opportunity to participate at the appropriate time virtually, just as if they were attending an in-person meeting. This notice was posted on the Millburn Township website, Millburn Town Hall Bulletin Board, and Millburn Town Hall front door. Roll call.
Hold on 1 second. I don't know. For some reason, I have Srini in the panelists and on the attendees.
Yeah, so I'm sorry about that. I just rebooted my computer, so I'm going to log off from here, and if you can just.
Oh, okay.
Thank you.
Daniel Baer,
Here.
Gaston Halpert,
Here.
Mark Matzel,
Here.
Maggie Miggins,
Here.
Joseph Steinberg,
Here.
David Morrow,
Here.
Vice Chairwoman Miriam Salerno,
Here.
Chairwoman Beth Zoll,
I'm here, and Srini Vijay is, I see as an attendee, so you can move him in and take his attendance as well.
For some reason, it's not bringing him over.
It's not allowing. Okay, we're having issues tonight, huh?
Okay, here, there we go.
Okay, Srini, if you're able to, oh, it looks like you're connecting.
And
Okay,
Srini is here as well.
okay, great. Wonderful. We have 2 sets of meeting minutes to review. The first, or the earlier ones, are those of September 22nd, 2021. The attendees were Dan, Gaston, Maggie, David Morrow, Srini, Miriam, and myself. And Mark, I'm sorry, Mark was there too. Apologies. I don't know if anybody had any comments or corrections regarding the minutes of September 22nd. Would anybody like to make a motion to approve the minutes?
I will make a motion.
Okay, great. I will second then. Thank you, Miriam. Okay, all in favor of approving the minutes of September 22nd? Aye.
Aye. Aye.
Aye.
Any opposed? Okay. Minutes of September 22nd approved. Next, we have the minutes of October 6th. Attendees were Gaston, Jorge, Mark, Maggie, Sanjeev, David, Srini, Miriam, and myself. And did anybody have comments or suggestions? Mark, go ahead.
Yeah, thanks. I was just wondering if DEP approved the flood hazard individual permit to develop in the riparian and buffer zones and the stormwater management plan, as well as the soil and water conservation district certification.
You're asking if subsequent to our hearing, if the DEP has awarded those?
Yes, if they approve them.
I'm not sure if we know that yet. Eileen, do you or Martha know where that stands in the process?
We haven't gotten them yet. We understand the DEP is rather backed up, and I think they just recently started working back in person. They were out for a long time, and we found even with permits that the township was trying to get, it took a long time. So I guess we could check on that, see where they're at.
Thank you.
Okay.
Okay, great. Thanks, Mark. That's it. And I'm guessing you're asking that regarding the resolution that was in included in the? Okay, great. Thanks, Mark. Okay, that said, does anybody make a motion to approve the minutes of October 6th?
I'll make a motion.
Thanks, Gaston. Anybody second?
I will second.
Beth, I think I need to recuse. That's Woodland, yeah?
It was Woodland, but you attended the meeting and
She
This
did not vote
was-
on the application.
you did
I mean,
not
on the
vote.
resolution, no. So
Right, so that's fine.
Please vote,
You're, that's fine to have you recuse. I think it's appropriate. That's fine. Thank you for confirming, Maggie. All in favor of approving the minutes of October 6th?
Aye.
Aye. Anybody opposed?
Recuse, since I was
And
on.
Dan and Maggie will recuse. That's fine.
Eileen,
for-
Sanjeev's getting on now.
Sanjeev, okay, yeah, I'll wait. Oh, did we lose Srini again?
I see he's in the attendees panel. I don't know how he got there.
Maybe he signed off. Okay.
Okay.
Yeah, I don't see Sanjeev yet.
Okay, you just said getting on now.
Okay.
Okay, great. So that said, hopefully he can join as we move into our one application for the evening, which is 21005 Daniel and Jenna Foreman at 36 Park Road. It's for minor subdivision approval, minor subdivision plan. So it looks like we have. Bring in Mr. Lanzafama and Mr. Foreman and
And I believe Mr. Kilstein.
Mr.
is
Kilstein
there.
as well.
They're adjourned. I don't know.
Hello, good evening. Is Mr. Kilstein, is that the council? You're in the room, but you're still, your camera's off and you are mute.
I'm muted. Now I start the video. There I am. Okay, good. Thank you, everybody. Shall I start the presentation,
Let
Madam?
me
Chair?
just bring Sanjeev over, so.
I'd like, yeah, if you could hold
Here.
for a moment. Right, I would like to
He just
announce
got
at
here.
7:40 p.m. Sanjeev
Yep.
Vinayak joined the meeting, and I'm glad because now Sanjeev can participate in the full hearing of this application. Thank you for your patience.
May I start now, or do you want?
Please do. Thank
Okay.
you.
Sorry,
Let
Okay,
me
well,
enter-
welcome Sanjeev. Thanks.
Thank you.
thank you.
Let me enter my appearance. My name is Neil Kilstein. I'm a lawyer with the law firm of Kilstein and Kilstein. We're at 619 River Drive, Elmwood Park, New Jersey. I am appearing on behalf of the applicants Daniel and Jenna Foreman, who reside at 36 Park Road. That would be Lot 1 in Block 1401. They are making an application for minor subdivision approval so that they can add to their undersized lot small portions of the adjacent lots to the east. Those lots actually don't front on Park Road, they front on Farley Road. Can we take care of the housekeeping details that we have filed an affidavit of service and we have given you proof of publication? Need that be noted on the record?
I have all of that, yes.
Okay, so we're good to go.
Yes.
Okay, so let me tell you a little bit about what this application is, and then I'll just have two witnesses, Dan Foreman, and our expert will be Michael Lanzafama.
Thank you. Mr. Kilstein, if I can, I apologize for jumping in, but I would be remiss if I let you go too far. I want to make sure you are aware of the professional reports and you had received copies of those professional reports.
Yes, we have, and it is our intention to respond to them. Mr. Lanzafama in particular will address it was just the engineer's report and the professional planner's report.
Perfect.
We
Okay.
will respond to those. Thank you for
Perfect.
bringing that up.
And I'm sorry to keep cutting you off. Before we get to the planner's report or before we get maybe to Mr. Lanzafama's testimony, I'd request that we have the opportunity to clarify some questions that have come up since we received that report. So our planner is here tonight, and we'd like to just make clarifications to our asks of you. So if you'd like to proceed, or if you'd like us to start with that, I can leave that to you. If you'd like to have us address that when you get to Mr. Lanzafama, we can do so.
I think that would make a better presentation. Ms.
Okay.
Bell. Okay, so the Foremans reside at 36 Park Road, and they're actually at the end of a dead end. So there's nothing to the east of them. That road stops. They're seeking to add to their property 2 small parcels, which they hope to acquire, which they've entered into agreements to acquire from their next door neighbors, the Kellys and the Schifrin Haynes. Those properties that adjoin their property face on Farley Road. One is 81 Farley Road and the other is 83 Farley Road. Those are very much larger properties. The taking of small portions of their property will still leave the Farley Road properties fully conforming. What this will accomplish for the Foremans are a number of good things. Number one, it will bring them into greater conformity with the bulk requirements of the R4 district. Number two, it will eliminate encroachments from the Foreman property onto the Schifrin Haynes property based on their steps. Number three, I think most important, is that after Dan Foreman and Jenna Foreman bought their property, they learned that the side yard on the easterly side of their property was only 2.2 feet, which of course is horrible. You can't even walk past it. By making this acquisition and adding to their property, they will have a sufficient side yard to go down. They will eliminate the encroachments, etc. From the public point of view, nothing will be visible. Nothing is being built. Nothing is being changed. You can look at the property both before and after the acquisition. It'll look exactly the same, nicely landscaped and attractive in the neighborhood. So with that introduction, I would call first Dan Foreman. Is he going to be sworn by somebody or affirmed?
Yes, he will. So
Okay. So
great.
my first
So,
witness is
Mr.
Daniel Foreman.
Thank you. And Mr. Foreman, if you would unmute yourself, and Eric, go ahead and you can swear him in, please.
Mr. Foreman, if you would just raise your right hand, please. Do you swear or affirm the testimony you're about to give in tonight's Zoom hearing to be the truth, the whole truth, nothing but the truth?
Yes, I do.
If you would just state your name and your address for the record, please.
Sure. Daniel Foreman, 36 Park Road, Short Hills, New Jersey, 07078.
Dan, I would just ask one question. Can you explain the circumstances which led you to make this application? What happened to you from the time you acquired the property so that now you're making this application to add to your property to the east, to small portions?
Yeah, sure. So yeah, we purchased our first time home in October in 2019. We had basically a brand newborn and a 4-year-old daughter. And I'd say this when COVID hit, this was probably early March. And my wife and I were talking about what extra activities we could do in the backyard. And we actually said to ourselves, you know what, we don't know where the property line ends on the side and on the back of our property. So I was like, I remembered us getting a survey after we closed. So we pulled up the documents and we opened up the survey and saw that there was a major encroachment of our stairs and that the side yard was basically in our neighbor's property. So obviously that was not a comfortable moment. So what we did was engage with Neil, and also at the same time, a few days later, one of those houses was sold, and the neighbor came over, and there was surveyors who were at the house, and they basically confirmed that the survey that we saw was accurate. So that took us down the path of engaging with Mike, and also getting a new survey on our behalf to confirm what we were told. So that's what happened.
And subsequent to that, did you enter into any agreements with your neighbors concerning the acquisition of a portion of their properties?
Yeah, both with the Kellys and Schifrin Haynes, as they've agreed to sell us the Kelly house, the conforming the minimum amount of space to conform with the previous variances, and the Schifrin Haynes is to sell us a much larger component, which is on there's actually a fence on that side of the house. So this land, there's land on what I thought was our side of the fence that's actually theirs. So they've agreed to a much larger sale.
Is it correct that your agreement with those two neighbors is conditioned upon your obtaining the subdivision, the minor subdivision approval that is the subject matter of this hearing?
Yes.
Okay. I have no further questions of Mr. Foreman.
Okay, thank you. Members of the board, does anybody have any questions for Mr. Foreman? Okay, and to any attendees, members of the public, if you have a question for Mr. Foreman based on his testimony, you could use the raise hand function and I could call you in if you have a question for Mr. Foreman based on his testimony.
No questions.
Okay, seeing none, great. Then thank you. We invite you to continue with your testimonies.
Thank you. My second witness is Michael Lanzafama. I wish to submit Mr. Lanzafama. I'm going to ask him certain questions about his experience and about his qualifications so that he can be qualified as an expert in land surveying, in professional planning and professional engineering.
Let me just swear him in. Do you swear affirm testimony about to give in tonight's Zoom hearing be the truth, the whole truth, nothing but the truth?
Yes, I do. My
Yes,
name
sir.
is Michael Lanzafama. That's Lanzafama. I'm a licensed professional engineer, land surveyor and planner, licensed in the state of New Jersey. I'm a principal with the firm of Casey and Keller Incorporated, 258 Main Street, Millburn, New Jersey.
Mr. Lanzafama, have you testified before this planning board previously as an expert?
Yes, I have, in all
And have-
capacities.
Having been previously qualified, I would submit, or I would request that the board accept his qualifications as an expert in those three fields.
Before just carte blanche approving, could you just restate the three positions and any certifications you have regarding those and whether those certifications are current?
Sure. All my certifications are current. I'm licensed as a professional land surveyor, a professional engineer, and a professional planner. I've been licensed as a professional land surveyor and engineer since 1984 and a professional planner since 1985. I'll be testifying this evening as a professional land surveyor and if need be as a professional planner.
Okay, thank you. Welcome back, Mr. Lanzafama, and we will hear him and accept him as all three. Thank you for confirming.
Thank you.
Thank you. Mr. Lanzafama, you prepared a minor subdivision plat with respect to,
Apologies. Yeah. So Ed, thank you, Ed, for correcting me. Do you want to, Mr. Buzak, who's our attorney, did you want to make the clarifications before Mr. Lanzafama jumps into his testimony? And Mike, I hope that's okay with you as well, just so
That's
we're
fine
all on
by
the same
me.
page. Thank you. Okay, so that said, everybody received our planner's report. Graham Petto is here as well. So hopefully you have that available either physically or virtually or digitally. Mr. Buzak, do you want to jump in and recategorize? I guess I know you had spoken directly with Graham today or yesterday.
Madam Chairwoman, and then Mr. Petto could certainly supplement whatever I say.
Thanks.
We received I received the report simultaneously, I suppose, of Mr. Kilstein and the board members. And the report has a section 3 related to variance discussion. And the planner points out 5 variances that need to be addressed in one way or another. Mr. Petto and I had a lengthy discussion today about that, and this application raises an issue of first impression for me, and I've been doing this for longer than I'd like to admit. And that is an issue whereby variances have already been granted for the 5 items that are set forth in Mr. Petto's report. And those variances in general under the law run with the land. And this application does not aggravate any of those variances. And in fact, reduces the deviation in some cases. In other cases, eliminates the need for a variance completely and makes the lot conforming in 2021, assuming the subdivision is granted, as compared to where it was in 2015. So the question becomes, what happens to those variances? And it's an important question, not just hypothetically or theoretically, but it's an important question legally and from the perspective of property rights. When a property owner receives a variance, as I said earlier, the variance runs with the land and it continues. And in the event that the structure in this case is completely destroyed, it can be reconstructed in exactly the same place it is, taking advantage of the variances that were granted. As a result of this application, and if the subdivision is granted, as I pointed out, a number of the variances that were deviation in 2015 now become conforming, and some of the other variances become less onerous, so to speak, or the deviation becomes less. So I think it's important for this board to deal with that issue now, not have it hanging out there sometime in the future. And again, Mr. Petto and I had a discussion today about this. And I think, I don't want to speak for him, but I think we are in agreement that we need to address these changes, let me put it that way, changes or modifications in the magnitude of the variances that were granted in 2015 versus what they would be today, assuming the application is granted. And the conclusion that we reached was that if this board proceeds to favorably consider or favorably grant this application, that the variances that were granted in 2015 need to be modified as part of this resolution, as part of the application before the board, to reflect the current conditions, current being assuming that the subdivision is granted, so that, for example, those variances that are eliminated become permanently eliminated. And in the event that this structure is completely destroyed, the applicant, the current owner, neither the current owner nor future owner could rely upon those 2015 variances, because the lot has now, or the structure in some case, in some aspects of the zoning, has become conforming. And they should not be allowed sometime in the future, if the structure is destroyed, to automatically take advantage of variances that were granted in 2015 that are no longer variances in 2021. So in short, what I'm going to be asking the board to do, and I know this is, Mr. Kilstein is hearing this for the first time, and so is Mr. Lanza-Fama. I think that the applicant does not have to reprove the granting of the variances that were previously granted that are now being either eliminated or being lessened, so to speak, in terms of magnitude. But that any decision of the board, favorable decision of the board, should include a modification of those variances to conform to reality today. And that is the variance that will be granted or eliminated. And if the applicant, the structure is destroyed and the applicant or the then owner wants to build a structure that is non-conforming with regard to that aspect, they would have to apply at that point for a variance. They can't rely upon the 2015 variance. So that's, I'd like to say the Reader's Digest, but that's a little bit longer than the Reader's Digest, but not
That's a little long. Thank you, Ed. Mr. Foreman, as this is your property as well, I just want to make sure, do you feel you understood what Mr. Buzak was saying?
Yeah.
Would you like me to try to paraphrase it, or you feel you understand what was being stated?
I don't think I could say it right now. I'd practice, but I think we're good.
Okay, great. That's fine. Thank you. And Graham, did you want to add anything or clarify anything in that, or you're comfortable?
I appreciate Ed's Reader's Digest version. That was very good. It just kind of, in brief summary, essentially the conditions of the lot are changing under the proposed minor subdivision. So, and the variances in 2015 were granted specific to that lot size, and the lot is now increasing in size, which changes that nature. So, but Ed did a great job of kind of succinctly going through all of that in detail. So thanks, Ed.
If I may speak, I think my understanding is that when a non-conforming use is more than 50% destroyed under the law, you lose the right to continue that non-conforming use, whether it pre-existed the zoning code or was granted by variance. So I think we'd go along with that. I think, would you agree with that, Mr. Lanzafama?
Yes, I would.
Okay, so yes, we would agree with council's position, and it is our intention through Mr. Lanzafama to bring you testimony which would justify the new variances based on the C2 standard. Am I correct on that, Mr. Lanzafama?
That's correct.
Okay, so then with that understanding, shall I proceed with Mr. Lanzafama's testimony?
You can, and I just want to confirm that you understand that Mr. Buzak is stating there is not the need to prove the C bulk variance relief.
I understood that. I think what Mr. Kilstein was trying to point out was that in our presentation, similar to a C2 variance, that what we're doing is only improving the existing non-conforming condition. So thereby it's certainly a better planning alternative than the existing.
Okay, thanks. I will let you continue. I just wanted to make sure we're all clear. Thank you.
My understanding is that if we've complied with all the requirements of your minor subdivision ordinance, we don't have to prove hardship, need, or anything else. We're just entitled to the minor subdivision approval. However, if you've seen, based on the prior grants and the opinions that have been expressed, that we need not offer any testimony as to hardship, as to all of the other C2 requirements, then we'll eliminate it from the testimony. Is that agreed, Mr. Lanzafama?
Well, I think we just need to present the application and let the board weigh in.
Okay.
I don't think we're going to get into heavy duty planning here. I think it's pretty straightforward.
Then let me ask you if you would run through and describe the contents of the minor subdivision plat that has been included as part of the application. And I'll let you just go, and you can start where you want and finish where you want.
Thank you.
My help.
Eileen, can I share my screen?
Yeah, you should be able to. Go for it.
Okay, what I've put up on the screen is the minor subdivision plat, which was prepared for this application by my office under my signature. And it's entitled Minor Subdivision Plat 36 Park Road, dash 81 and 85 Farley Road, and consists of 3 tax lots. 36 Park Road is tax lot 1 in block 1401. Go ahead,
Mike. I'm sorry. I'm going to jump in. I'm going to ask that we can call this Exhibit A1.
All right, this is the exact drawing that was submitted as part of the application. But yeah,
Ed, are you comfortable with that numbering? What do you prefer?
Yeah, no, I think it should be marked as Exhibit A1. We always mark exhibits despite the fact that they've been submitted for the record. We need to mark them so that there's a clear record of this in the future.
okay. So the minor subdivision plat is being marked as A1. So as I was saying, 36 Park Road, which is at the terminus of Park Road, is tax lot 1 in block 1401. And then the 2 lots that are conveying property to us is 81 Farley Road, which is tax lot 31 in block 2406, and 85 Farley Road, which is lot 1 in block 2406. All 3 properties are located in the township's R4 residential zone district. And as you can see from Exhibit A1, the minor subdivision plat, the encroachments that Mr. Foreman was alluding to, the staircase, retaining wall, and the existing fence that is on the 81 Farley Road property. So the perception by the Foremans and by the property owner of 81 is that the property line, it runs along the fence line, you would think. But it turns out that that is not the case. The property line is actually this dashed line that you see through here, which we wish to eliminate as part of this application. And what we are proposing to do is run the new property line along the fence line at 81 for 81 Farley, and from the current northeasterly property corner of 36 Park Road up on an angle to the common dividing line between 81 and 85 Farley, jogging over 7.36 feet. And then, as I said, continue approximately along the fence line. And what that does is it creates a 15-foot setback at the back corner of the garage. It totally includes the encroachments. So the encroachments would be wholly contained on the Foreman property. As a result of the application, the transfer of land, the Foreman property goes from 9,824 square feet. And actually, there was a typo on my zoning table. The Foreman property goes to 11,219. When we added up the numbers, we had neglected to include the 135 feet from tax lot 1. So when you combine the two, 1260 from lot 31 and 135 from lot 1, the total number increases by 1,395 square feet to 11,219. And as you're aware, the R4 zone requires 20,000 square feet. So although we're still non-compliant, we are vastly improved over the existing condition. The lot width for the existing lot, the Foreman lot, is 67.72 feet. That would increase to 71.39 feet. Again, reducing the extent of the nonconformity. However, the 100-foot lot width requirement for the zone is still not met. There's no change in the lot depth, which is actually compliant to the zone at 150 feet. There's no change to the front setback and the side yard setback on the east side. Obviously increases from 2.61 feet to 8.58 feet. Now, as to the building coverage and total lot coverage and habitable floor area ratio, obviously there's no improvements being proposed, but by virtue of the additional land area, the nonconformities on the Foreman lot for building coverage reduced from 22.3% down to 19.7%, whereas 14% is permitted by the zoning for building coverage. For total lot coverage, 35% is permitted. The existing condition is 36.8%, and that's being eliminated because the new lot coverage percentage would be 32.6%. So that is now compliant with the zoning. And a similar situation occurs with the FAR. 26% is permitted under the ordinance. We're at 28.7%, and that would be reduced to 25.4%, which then brings us into compliance. So as you can see, this is truly a win for the Foremans. The other two lots still remain totally compliant with the zoning as far as lot areas, all the bulk standards, FAR coverage, and building coverage are all still compliant, even though they're conveying off parcels of their land. So that's pretty much the application. And I'd be happy to entertain any questions the board members might have with regard to this application.
Mike, before you get to that, I just have one question for you. And that is in the township engineer's memorandum, he recommended the placement of corner markers, I guess, at the critical corners of the new
Yes.
corners. Has that been addressed or?
Well, that hasn't been done yet, but it will be done.
Thank you.
Yeah, there's an existing iron at the current corner. We'll be setting irons at each change in direction along the new boundary line.
Thank you. I have nothing further to ask of Mr. Lanzafama, Chairperson.
Great, thank you. And Mr. Kilstein, I don't know if you're able to put your video back on. We can't see you at the moment. I don't know.
You
what
might be
happened.
you might be better off, but I'll try it again.
Okay, thank you.
Okay, there you go.
There we go. Thanks. Do any members of the board have questions for Mr. Lanzafama on his testimony? Okay. At this time, do any members of the public have questions for Mr. Lanzafama based on his testimony? Using the Zoom raise hand function, you could raise your hand and we could bring you in to ask any questions. Okay, seeing none. Thank you. Go ahead, Mr. Kilstein. I allow you to, yeah, before you, I don't know if you're going to wrap up or not.
Well, I don't even think that we need to wrap up. It's a compelling application. It does harm to nobody. Nobody's going to be able to see that there's any change as a result of the granting of the application or the addition of these properties, which will be memorialized after the appeal period with deeds from the two adjoining property owners to confirm the minor subdivision. And it's a win-win for the borough. It's for the the township. It's a win-win for the Foremans. It does no harm. It is only good, and I would request and submit that the application should be approved.
Great, thank you, Mr. Kilstein. Okay, and before the board moves to vote, I just wanted to open it up for any comment from members of the public. So it could be agnostic to whom they're addressed, but if anybody from the public wanted to make any comments regarding this application, now is the opportunity.
I have just one comment. And that
Okay,
is,
let's Joe first. I was opening it to the public, but now seeing none, I will allow it to go to the board. So please go ahead now. Thanks.
I'm sorry.
No, it's okay.
I think that it would be appropriate for our attorney to state specifically that in his opinion, the notices that were sent out with respect to this hearing by the applicant did not have to contain any mention of the variances. If that is in fact his opinion.
For the record, Mr. Steinberg did raise this issue with me, as he sometimes does before the application is actually heard. That actually prompted the discussions that led to the earlier explanation. So I am satisfied that the notice that was provided did not have to set forth any variance request, because the variances had all been previously granted. And as I said, we're not granting new variances as such. We are modifying the old ones to now conform to reality, assuming the board grants the subdivision approval. Thank you, Madam Chair.
Council, it's a saving I should quit while I'm ahead, but I could mention that the notices that were sent out didn't mention any required variances there. It isn't naked. It does the notices that were published in the newspaper and to the neighborhood said together with such variances as may be required. It may say the applicant may also seek other variances and waivers as the need may arise during the course of the hearing on the application. So I think we have given the public notice that there may be during the course of the application exactly what happened, the need for variances.
Great, thank you, Mr. Kilstein. Okay, any other comments? So Joe, are you satisfied with council's confirmation? Well, Joe, you're muted.
I disagree with the statement just made by the applicant's attorney. That language, I think, is there for a very specific reason and does not cover the situation tonight. But I think that Mr. Buzak's statement is accurate, and we would agree with it.
Thank you. Okay, does anybody else have comments or discussion items? Okay. Would anybody like to make a motion on this application?
Madam Chair, before someone moves on the application, I just wanted to frame the motion for consideration
Thank
by
you.
anyone who may want to make it. And it would be to, if it's a favorable motion, to grant the minor subdivision as presented. I'm going to go through the modification of the variances, and I want Mr. Lanzafama, Mr. Kilstein, and the board to listen carefully, because these are going to be incorporated in the resolution, and they will, and also Mr. Foreman, obviously, because he and his successors will be bound by these. And these are taken from the testimony that has been provided, which was reflected in the papers that had been filed. In addition to these variances, let me just go through our regular conditions that we would normally put on, including the requirement that perfection of this subdivision by either file plat or deeds be completed within 190 days after the adoption of the resolution in accordance with the statute. And also two specific conditions. One, the recommendation made by the township engineer regarding the markers at the critical points in the meets and bounds, or the description, so that everyone knows exactly where they are in the field as opposed to on a piece of paper. And secondly, that the parcels that are subdivided, that are removed from the two lots on Farley, that a condition be that the subdivision would be granted only if those two parcels are conveyed to the Foreman property and appended to that Foreman property. So we're not creating orphan undersized little lots as part of this application. The variances that will be noted in the resolution will be as follows. And number one, the minimum lot size or lot area permitted will now be increased to 219 square feet as opposed to the 20 that is required. The minimum lot width will be increased from, the variance will be reduced from 67.72 feet to a width of 71.39 feet. And that again is still non-conforming versus 100 feet that will be required. The minimum front yard will remain the same, 37.69 feet versus 40 feet that is required. The minimum side yard will, the variance will change from 2.61 feet as currently granted by the Board of Adjustment to 8.58 feet. That's still non-conforming versus the 22 feet that would otherwise be required. The minimum side yard aggregate increases to 26.2% as opposed to the 19.06% that was previously granted. That is as compared to 35% required. Maximum building coverage The variance is modified from a 22.3% coverage to a 19.7% coverage, still deviant because the ordinance requires 14%. And the two other coverage requirements, the maximum lot coverage and the maximum floor area ratio will be changed to the maximum lot coverage will be changed to 32.6%, which now makes it conforming versus the 35% that we have. And the maximum FAR is 25.4%, which makes it conforming because the requirement is 26%. On those last two, the applicant can still go to the maximums from where they are now without seeking any further variances. They're not bound by obviously the lower coverage that is created as a result of any subdivision this board grants. So those are the specific modifications, Madam Chair, that I would like any resolution or any motion to be made to include. Thank you.
Mr. Buzak, can I ask a question, please? I have a copy before me of the Board of Adjustment variance grant, and I believe the side yard was not 2.2, it was 7.9. If you look at the prior approval. It is actually 2.2 now, and that's another story, but the prior approval was for 7.9. Mike, do you confirm that?
Well, that's my understanding. That's what's in the resolution.
Yes, it's in the resolution.
I will note that as well, and clarify that point that the variance that was granted was for a 7.9 foot side yard. I guess it actually turned out to be I have 2.61. Somebody mentioned 2.2, but in any event, the side yard now, the variance will be for an 8.58 foot side yard.
Thank you, Mr. Buzak.
Thanks. And before we move forward on making a motion, David Morrow, did I see your hand raised? I don't know if you had a comment or question to make.
Inadvertent click, sorry.
No problem. Okay. Would anybody like to move forward making a motion based on the support from Mr. Buzak? I move to approve the application given the changes to variances as outlined by Mr. Buzak.
I second that.
Thank you. We'll take.
Daniel Bear,
Yes.
Gaston Halbert,
Yes.
Mark Matzel,
Yes.
Maggie Miggins,
Yes.
Joseph Steinberg,
You're muted, Joe.
Yes.
Sanjeev Benayak,
Yes.
David Morrow,
Yes.
Miriam Salerno,
Yes.
Beth Stoll,
Yes. So the yeses have it. We have moved to approve the minor subdivision approval in this application.
Thank you very much, ladies and gentlemen.
Thank you very much for your approval. I would request Mr. Buzak to send me the resolution so I can review it after he's drafted.
Absolutely. We will follow up as such, and we hope for many future planning applications as nice and tidy as this one. So thank you.
Thank you.
Yeah, thank you, everyone.
Good night.
To the members of the board, don't all leave yet. Looks like everybody's hanging in. Okay, we are almost concluded, but I wanted to just bring up one item of new business. Yeah, we don't have a new business section on our agenda, but just sort of a heads up for the next meeting we have, which is coming up in 2 weeks. As you may recall, hopefully from 2 months ago, and Sanjeev, I see your hand, but I'll get there in just a moment. We had provided feedback on a draft ordinance that we received at our board that came from our TC. And we provided feedback, you may recall, specifically regarding loading spaces, loading zones with residential multifamily units. uses specifically saying, well, how, is it just one for a building? And, so we provided feedback to the TC. And my understanding, I've heard that they have taken that into advisement and are redrafting that specific ordinance. So it will come back to the planning board, hopefully reflecting some of our comments for our review after it has been introduced and read at the next, I believe it's next week's, or when is it coming?
My understanding is we will have, it's being introduced. We will have it for our meeting on the 15th.
Right, so we'll have it for our meeting on the 15th. So just the heads up there is that we're going to have another ordinance, and it should be similar, but hopefully reflective of our comments. So it's great teamwork to see that, the planning board's comments are being taken into consideration by our leadership. So that was all I wanted to say. Okay, I think Mr. Kilstein, you can go ahead and mute, or we can maybe move him back to attendees. Thanks. Okay, that was it. It is 8:24. Unless Sanjeev, did I see you raising your hand, or was that also an inadvertent?
No. So my question was on that, on 12.7, we are going to review that same loading and unloading again. I have seen an updated version, a little bit like the substance one. And I think Graham here is going to work on explaining it further. I thought it would be read here first and then go back to TC. Probably it is the other way around. We are going to see it first and then it'll come down here. But it looks better than what it was before. And thank you so much for everyone's input there on that one. Truly appreciate it.
Great, no, thank you. And that's exactly the intent of how this process should work. It should be iterative, and I'm glad to see that we're all listening to one another. So just, yeah, it reinforces that. So thank you. Okay. And with that, a thankful holiday season. I hope everybody continues to stay healthy, safe, enjoy holidays if you're celebrating now, and we will see you in 2 weeks. I make a motion to adjourn at 8:25. Can I get a second?
Second.
All in favor?
Aye.
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 Okay, good night. Thank you all.
Good night.
Night.
Right.